Well, hi, everybody. Again, this is Andy Yost with the Capacity Building Center for Courts. Thanks for joining us here for our ICWA Constituency Group April meetup. We have a jam-packed session today, which should be a lot of fun. Our creators from North Dakota, Heather, I think I said that right, Heather, you'll have to check Dakota. Heather Trainer and Melanie Sage from the University of North Dakota are going to be providing us with some material around ICWA compliance data and instruments, which is the topic that we'll cover today. So I have to say, and you'll see in just a minute when we get there, that they have a really, really nice PowerPoint. And I'm not always the world's biggest fan of PowerPoints, but I was pretty impressed with the quality of PowerPoint that they put together in terms of not only its aesthetic, but its content, and sort of leveraging the visual cues of a PowerPoint to drive the content. So anyway, looking forward to that. Should be really, really fun and exciting. Again, just by way of getting started here, remember the purpose of the ICWA Constituency Group is to share emerging knowledge among the group to improve court systems and dependency court systems, and we're working explicitly or deliberately, I should say, with the court improvement program in each state or their designee, as well as the tribal court improvement program. So welcome to everyone who's participating in those programs. We're glad to have you on. The second piece that we'll cover today toward the end is to set the agenda for next month's meetup as well as the day. So know that that's coming down the pike, and we'll also do some self-selection with regard to roles that people will play. So that's the intent of today's meeting. Real quick rundown. I know I assume everybody knows Connect, so I won't go too much into this, but just so that you know what you're looking at your screen, in the middle is a slide deck. We'll use that as a placeholder and then later on to deliver some content. Bottom left-hand corner of your screen is a pod with our agenda. The numbers and brackets are the amount of time we'll spend on each one. In the middle is a chat box. Remember, the chat transcript is saved, so if you have a brilliant idea, make sure you get it in the chat box. We go back and create summaries of each one of these meetups so we can mine the chat transcripts for good information. And also the chat transcript is saved. That's hard to say. And also, of course, the webinar itself is recorded. If, however, you want to have private conversations with each other, we absolutely encourage, welcome that kind of interaction. All you got to do is in the right-hand side of your screen, there's a list of attendees. Just hover your cursor over somebody's name and a little box will show up that says Start Private Chat with some other options as well. Just click Start Private Chat, and that will actually be a truly private conversation. That transcript will not be saved, and none of us will see that conversation as well. So if you're sharing information or you want to discuss some, tangentially related but important topic, then go ahead and do that. That's the whole idea behind the community of practice and the ICWA Constituency Group sort of writ large. So as I mentioned, we have, as always, myself and Scott Trowbridge from the Capacity Building Center for Courts and Heather Trainer and Melanie Sage from North Dakota. So I won't go into gory detail about everybody's credentials, and I'll let them kind of speak about the project that they worked on and the role that they played in that project when we get to that section of the meetup. So as always, what we'll do now is kind of just test the pulse, literally and metaphorically, of the people that are on the line. So I want you to just type into the chat and make sure that your functionality is working well. I want you to type into the chat the answer to this question. If you had 3 days and an unlimited budget and could travel any place on earth, where would you go? So just type into the chat that place. Make sure that you're up and running and that everything. You should see your dream location show up. Kathleen's the first. She's probably been thinking about Hawaii for a while. I actually used to live in Hawaii. And it is an exciting place to be for sure. Good. We're getting lots of responses here. Wonderful. So just shoot that in there and make sure that really, this is a fun way to get started, but it also tests functionality to make sure that you can engage the group. And it shows me that people are engaging the group. Not that I need to check that, but technologically I can see that everything's working. Great. Wonderful. Yeah, Kimberly, I actually went to Paris last year and got my Lost Generation on. So if you haven't been, I highly recommend it. Good. All right, wonderful. So looks like everybody's tuned in and responding, which is great. So let's just do a real quick review now. We'll just go ahead and get started. What I want to do is a real quick review, and we'll do less of this each time we get together. So I apologize if you feel like this is super redundant. But for those of you that are newer to the group or maybe just haven't heard this spiel before, I think it's important at least structurally to get it out. I want to go very briefly over the different roles that are available for folks to play or adopt in participating with the constituency group. I won't go over point by point all of the attributes of the constituency group, but just as a reminder, it's that emerging knowledge kind of thing that we've talked about before. So it's crucial that we all are kind of clear on what the roles are. So there's 5 different roles that someone can take when they are engaging the ICWA community of practice. And everybody's got to pick one, but you only got to pick one. If you want to pick 2 and you're ambitious, that's fine as well. Really, there's 4, though, because the last role is the caretaker role, the person who manages the learning community. That's the capacity building center for courts. So that's all of us that are on the line here kind of working behind the scenes to storyboard stuff and make sure that the Connect room is up and running. The other 4 roles are these. First of all, it's a consumer. Everybody on the line right now and in the room in some ways is a consumer, but your explicit role as a consumer is to look for and use the content, information, and social connections that we create. So, in a sense, if you're not a creator, connector, or carrier, you're a consumer. Creators are people who create, share, improve, and discuss the content and information. They can be from inside, like last time, or from outside the community, like this time. And Melanie, I don't mean that in any deep ethical sense that you're an outsider, only that you are sort of giving us a perspective from outside of the group itself. The connectors are people who help others to find content information and the people that they seek or need. So you're connecting creators with information that is out there. And carriers are people who help the creator to transmit and promote their content and information to others. So connectors are connecting ideas and material. Carriers actually doing the distribution, and creators doing the presentation. We've already mentioned caretaker. So when we get to the end, when we spend a few minutes thinking about roles, once we decide what the next meetup topic is going to be, and we will do that before we self-select roles, ask yourself what you can contribute to the group as a consumer, creator, connector, or carrier. So anyway, that's just sort of by way of reminder in terms of where we're headed at the end and the roles that folks are playing. And then the last thing that I'll do, and I promise Melanie I will be quiet, so you can get started here. In fact, I'm going to give you some minutes on the front end that you can just have for free that don't count against your 30 minutes. Is just to say thanks. So this month, the creator is Melanie Sage, and she's being supported by Heather Trainer out of North Dakota, which I mentioned. Our connectors this month that we're working behind the scenes are Michelle Zackard, Stacy Tadgerson, Stephanie Pospisil, Heather Trainer as well, and Crystal Duarte. So thank you to you, 1, 2, 3, 4, 5, who kind of behind the scenes were spreading information around and uploading them and sending them to me. That's great, so I appreciate that. And then I'm the carrier this month, which just means that I'll put together the summary at the end and I'll send it out to the group as a whole. The very last thing that I'm going to say is that I want to encourage people when we move into the lunchroom and we start sharing information to, if a piece of information comes up that you want to share, a resource that you want to share, send it to me or Scott, preferably Scott just because he's faster than I am, but I can take it too via email and we'll upload that information into the ICWA Exchange today. Crystal sent me some things vis-a-vis Ann Gilmore, so thank you, Ann, for that. We also have an ICWA Compliance Toolkit that we'll talk about just a little bit later. I see Scott typed his email into the chat, and then later on when we're in the lunchroom, I have it posted as well. So anyway, the idea is that we don't wait to share, that we share now. So if you get that stuff sent to us as an attachment, we'll get it up into the exchange right away. So, all right, I am getting tired of talking, and my guess is you're probably getting tired of listening to me talk. So without further ado, I'm going to invite Melanie, you're up, to work with us through your, give us the presentation that you have on the work that you've done in North Dakota. So Melanie, you there?
Yes, can you hear me?
Yes, we can. Thanks, Melanie.
Okay, perfect. I'm getting used to where everything is on my screen here, and it looks like you're loading up. Are you pulling up? I'm Melanie Sage. I'm an assistant professor at the University of North Dakota in the Department of Social Work. And Heather and I decided that the way that we would work this today is that I would just kind of take the lead in talking a little bit about the work that we've done, and she'll chime in at certain points here. It looks like my PowerPoint is moving really fast, and I don't know how to make it stop. Give me a minute here. All right. It's really exciting that you have this National Learning Network to talk about ICWA. I was just at the NICWA conference in Minnesota, and we were talking about ways to collaborate better and share national strategies. So I'm really glad that these calls are happening. Where we're going to take this kind of orientation to our work today is really from a process perspective in talking about how we've gotten to where we are, but also from the perspective of kind of what it takes to think about assessing compliance in your own state. And so I'm going to give a little bit of an overview of the different methods and ways of doing this. I'm going to start my web camera just for a minute here. I don't know whether I'll keep it on or not, but I wanted to be able to say hello and let you see me, because I know that having that orientation to person in place can be helpful. So is there any way to make the PowerPoints a little bigger? I'm afraid the text is going to get lost in this size screen.
Yeah, you bet, Melanie. We'll fiddle with it as you go, for sure.
All right. So I have a relationship with the Supreme Court through an RFP that they issued asking somebody to look at compliance for an audit of the courts. And so I work here at the university with Avery Erickson, who's my research assistant on this project, and she helps me with the data tracking and analysis. Let's see. Okay, so here's what I hope we can do today. I want to tell you a little bit about what it's like to work with the university if you're a court system, and talk a little bit about challenges related to assessing ICWA compliance. We'll also talk about strategies, different ways that different jurisdictions have gone about assessing compliance. And I hope that at the end of this we can have a bit of a conversation about ways that you would incorporate some of these ideas into your own communities. So I like to start with this quote. We do what we measure. This is by an evaluator. She says, "We live in a culture that's crazy about numbers. We seek standardization, we revere precision, and we aspire for control. The very ancient and dominant belief of Western culture is that numbers are what is real. If you can number it, you can make it real. Once made real, it's yours to manage and control. We have to know what's going on around us, how our actions impact others, how the environment is changing, how we're changing. If we don't have access to this kind of information, we can't adapt or grow. Without feedback, we shrivel into routines and develop hard shells that keep newness out. We don't survive for long." I like this quote and share it to remind us both of the importance of data-driven processes and how counting something really helps us think about how to change something. And a lot of us are thinking about how to improve the systems. But I also share it so we remember the orientation of this kind of number-obsessed culture that we live in, and that we don't lose sight or become too full of ourselves related to the stories and tragedies and experiences and the real lives that are impacted by this kind of work. So with that said, some questions that I think are good to start thinking about if you're thinking about evaluating compliance in your own community are questions like these. Who gets to create the measure? And is it meaningful to the people who are doing the work? And maybe even more importantly, to the people who are affected by the work? How do we measure the measures? How do we know that the tools we're using are actually useful in the end? And how are we going to use the outcomes? So sometimes we think of really great things to measure. And if you think about the backside of that, like, well, what will you know when you're done with this? And is this really going to help with things that are within our realm of control to change or are going to be useful in some way? And the last question that I have here for your consideration is, does this measurement really increase our capacity to learn and grow? Sometimes knowing some things has drawbacks as well as benefits, and I'm sure that you can all consider what those might look like from your perspectives, but I really give North Dakota a lot of kudos for wanting somebody from, let's say, the outside to come in and do this work for them, and know that there are some ramifications about sharing how well they're doing in a public setting. Okay. So North Dakota wanted me to help them figure out whether their cases were compliant. And so an early question is, what is a compliance case? We get a little bit of guidance from the 1978 original legislation. We get a little bit more guidance from the BIA updates. And so we have some general themes of things that we're looking for when we talk about compliance, and I have some of them listed here. North Dakota is not a state that has other state standards related to ICWA compliance, but some states do. So when you think about developing research questions around compliance, an important start is thinking about what you want to know and how you'll measure whether you know that thing. So, for instance, if you want to know in this research question in the white block here, are courts providing timely notice to tribes in ICWA cases? Then you have to know how you identify timely, and you want to know how many days are required for each piece of documentation and what piece of data you have to look about whether that is true in the case that you're looking at, right? So there's a little bit of an involved process for looking at every single data point that you're thinking about, but not only at the case level, because notice happens for every single hearing, not only every single case. So if you broke down this question to just an ICWA case to try to think about whether this case is compliant with notice, probably there's a notice error somewhere along the line in every single case, and you'd have a really low compliance standard if you only looked at it at the case level and said, no, this is not compliant if there was one error in notice somewhere along the way. So you consider how issues like that impact whether you say a case is compliant. One of the things that we had a conversation about early in our work on compliance with North Dakota is whether and how we set benchmarks. And when I first came on to this project, the thought was, well, we want to get sort of a benchmark of how we're doing, maybe a goal benchmark. And that's pretty common in analysis, like, well, we want 80% of our cases to reach this level of compliance on this measure or whatnot. And my stance as a researcher on this piece is that ICWA is the law, and there's really no acceptable level of not following the law. So we kind of pitched the idea of benchmarking. Instead, we said, well, we're going to try to make some assessments about where we are and look for improvement and ways to improve. All right. I want to talk for a few minutes about some different ways that compliance has been measured, and this is from a review of the literature. One way is to look at court record review, and this is the method that we're using. So the North Dakota court record system is called Odyssey, and it contains minute orders and affidavits and attachments and return receipt cards and things like that. Another way to look at ICWA compliance is to look at the social services record. And several projects have done this. There was a project out of Arizona in 2012 that used this kind of method, did some interviews alongside with looking at the social service records, and those are often random file audits. Another way is to do direct court observations, to sit in on hearings, for instance. And CWICWA out of Minnesota is one method of doing this. And so they have I think maybe a 15-point checklist or so. and actually sit in on hearings and determine whether at that hearing standards of ICWA were met. And then the last way is just using qualitative strategies of having conversations with key stakeholders. So there are strengths and weaknesses to all of these approaches. One of the just like common sense issues is what data can you really access? And so for our project, since it was a contract with the court, they made an agreement to share the court records. They're online. They were accessible. We could do the work from the university, even from a distance. And so after you figure out what you can get a hold of, you can kind of narrow down your strategy a little bit more. In our state, the courts are not open, so it would be harder to have an agreement for somebody to do a court observation project, for instance. And one of the other struggles with court observation is not only the manpower of getting somebody notified into court for every hearing, but it's really hard to track a case all the way through. So it's hard to determine whether a ICWA benchmark was met at a previous hearing that maybe the court observer hasn't been to. For instance, if we're looking for clear acknowledgement that this is an ICWA case, maybe it happened in an earlier case, but not the case that the court observer is sitting in, so it would be hard to tell whether that issue was met or not. So you all know the answer to this question. Whose job is it to assure compliance with the law? One of the conversations that comes up when we start thinking about compliance is like, who's done this work and where does it get tracked? So we talk about issues like whose job is it to assure active efforts? The courts often say, well, that's in the social work case file. Maybe the details about that aren't going to show up in our file, but the worker will tell us whether the active effort standards were met. And then I hear from caseworkers that, well, active efforts is a legal term, and we think that we've done the job, but the court tells us whether or not we've actually done that. They interpret the law in that way. So this piece about not having a real place in our world for who's the bottom line on this is problematic. My stance as a researcher, given that this is a legal standard, is that child welfare, the state system or county system should certainly be involved in knowing what ICWA means and what they're supposed to do, and ultimately I would hope that all these things flow up to the court record and get documented there in the court record, which not only helps with kind of knowing where the stuff goes, but also helps with assessing compliance. I want to tell you just a little bit about North Dakota's American Indian children. We have one of the highest rates of disproportionality in the nation. That is the number of children in the system compared to the number of children in our community. So this number is actually up a little. I need to update the statistic, but North Dakota's American Indian children make up about 10% of the population here, but about a little over 30, closer to 35% of the kids in foster care in our system now. We have disproportionality issues across lots of different social problems, including poverty and education. So that gives you a little bit of a frame of reference about the situation in our state. And is one of the reasons that we have a ICWA subcommittee in our court improvement project who really wanted to explore and dig into some of these issues related to disproportionality and see what we can do about changing this situation in our state. So the ICWA subcommittee set out to try to do an internal audit of ICWA compliance, and they sort of divided up the cases between them and tried to figure out, without much external guidance, about what a compliance case looked like or didn't look like. And they all came back together and compared their notes, and I think maybe argued a little bit, maybe that's too strong of a word, but about how to interpret whether a case was compliant, and ultimately decided that they'd like to have somebody come in from the outside and think about compliance with them. So they issued a request for proposals for somebody to help determine whether cases were compliant, and that was drawdown funding federally through the CIP project. And they issued us here at the university a 3-year award. That was in 2012, 2013 we began this work, and since then they issued a 1-year extension. So we're wrapping up at the end of this year in our funding through that project. We have a flag in our court management system that helps identify whether cases may be ICWA eligible. So we were sent the access numbers for each of those cases that held an ICWA flag, which means that we looked at all cases in the state which were deemed ICWA, that they may be ICWA eligible. However, that also means that we looked at no cases in the state where ICWA was, there was a failure to identify a case as potentially ICWA from the very beginning. So that's part of what's missing from our case. However, this is the very first statewide audit of all cases that are thought to be ICWA eligible. So we're pretty excited about breaking some ground in that sense. I'm going to take a breath and just read your comments really quick to see if there are any questions about this so far. How much was the RFP funded for in case we would like to consider budgeting one for ourselves? We drew down, we have a contract for about $50,000 a year for this work, and that includes about a 0.55 FTE research assistant who works with me on this project, who does the actual case analysis, and it pays for a little bit of my time for supervision and dissemination and things like that. And I don't hold any of this stuff close to my vest. Anything you want to know about any of this or any resources, I'm happy to share, and hope that it helps you think about how you might do some of this stuff. So one of the things that I want to talk about is that there is some tension between the work of court systems and the work of academic researchers. And there's a really good resource here that, from NCJ, FCJ, on creating judicial academic partnerships that points out some of these tensions. So often, you know, the court systems, they want to understand their data, sometimes want a pretty quick turnaround, want to be able to make quick decisions. And us academic research types, we want to move things so that we can disseminate them. We want to publish our research. We want to share with the community. We want to inform practice on a wider national level. We want to take our time with the data to really understand it. So there are some different goals which can be complementary, but can also create some tension. And those are some things that we had to negotiate early on in this partnership. We took some time, for instance, and several backs and forths that involved our attorney, lawyers, related to how this work could be disseminated. Some universities have evaluation centers who are pretty happy to take in money for just a pure evaluation. But as a tenure track professor, I have an obligation to share and disseminate, and it's part of our university's mission. So my involvement in this project was partly contingent upon a data sharing agreement. So that's what I was talking about when I said we had to come up with a disclosure and data sharing plan. It might be informative to say the way that we landed on this is that anything that we publish, we'll have the data approved first by a court process. We take it to the CIP committee after the subcommittee sees it, and then it goes up to our judge for final sign-off. And so we have a little bit of a lag, but it meets both of our purposes that way, about having some protection around the data and also using the data. So here's what we did here at the university. I took a good look at all the research about what's out there around audits and checklists and literature and best practices. We had to operationalize each variable we were looking at and make sure we were clear about our research questions. We've used the subcommittee a lot, and I think that this is really important. So our subcommittee is made up of tribal social services directors, ICWA workers, judges, commissioners, the state child welfare directors on our subcommittee. There are several attorneys, prosecuting and state's attorneys on the subcommittee. So these are all people who see what this work looks like in action from various standpoints. And it's important to have their feedback about, did these definitions make sense? I'm a social worker, not a lawyer, so at some points I've needed some help in interpreting the law and make sure that I was clear on how I was understanding those pieces. And certainly we want the tribal perspectives when we're talking about data that ultimately impacts American Indian children and families. So we did that collaboration. Every time I worked toward defining a variable, I took it back to the subcommittee, said, does this make sense? When I collected data, I took it back to them, said, does this make sense? And what are your explanations for this? What do you think this means? Okay, so here's just a little timeline of our work so you can understand how it has been a little slow moving. The court opted for a historical study, so we weren't looking at data cases in time. We began with 2009, 2010 data, even though that we started this work in 2012, 2013. So one of the things that means is that with any finding we looked at, we said we had to be able to say, so this was true several years ago. This may or may not be true right now because some changes have happened in our system that affect ICWA compliance since the time and point we're looking at for this data. The good thing about that is that it gave us sort of a flat level. What I'm trying to say is the intervention, when you measure something, it's an intervention in itself. So especially if you're doing like court observation, somebody's in the room, what happens in court is going to be different just because you're measuring it, right? By us doing this audit and all the judges knowing in the state that we're looking at this kind of data, it's going to affect what they do in the court, and it's an intervention. And that's a good thing because when we talk about ICWA and measuring and assessing ICWA, it elevates the conversation to something that we need to be paying attention to. But by looking back at the data a few years ago, we weren't having that observation effect, that intervention effect on the data. There was a question about how many tribes are in North Dakota. 5 federally recognized tribes, that's true. But we've also, as part of the study, recorded where kids come from, what tribe, and there are about 17 different tribal affiliations represented in our data collection. Okay. So if you're using a data tool such as the court system that we're using, you got to think about how your researchers are going to get access to it and know that there might be some system hurdles to jump around sharing that kind of data. So it took us many months to get to that point where we actually had data access, longer than we expected, which affected a lot of things like I had already hired somebody to help with this, and then we didn't have data access. Once we finally got that first fiscal year of data assessed and we're ready to start thinking about moving on to the next year, we had to move that data through several layers of checks and do some adjustment to the reporting. We're now working on the second year of data, and like I said, we'll finish up the third year, fiscal year that we're looking at the end of this year. That third year, we'll probably do a little bit of narrowing of the number of variables that we're looking at and I'll tell you more about that in just a minute. One of the outcomes of our first year of data analysis, after we did some reporting around the state to stakeholders, was that question about well, where is this information supposed to be located? And so we've done a little project this last summer in one county where we looked at multiple sources of data, including the court audio record and the social services record, and I'll tell you more about that at the end of the presentation. So here are some other things to think about and some lessons that we've learned while looking at the cases. One, there's a lot of relearning that happens. So you might assume that once you kind of get in the flow of finding where information is located inside of a case, it gets easier. And that's a little bit true, except that we found that every county in our state court system documents their information in a little bit of a different way. And so it slows us down every time we go to move on to a different case. We found that in several instances, we have to look at several different kinds of documents to assess clients. For instance, in the issue of noticing, we're looking for dates and timelines, and we're looking for those return receipt cards, and we're looking for finding in the court documentation. And we might want to know other things, but we can only know what is there right in the court report. So we don't know the story behind those things, and often that missing piece would help us explain some of what's happening. We've often found that it wasn't enough to just document the kind of yes or no or a very quantitative measure related to a finding, but we also captured some qualitative information so that we could talk in the reports about exceptions. For instance, we'll stick to the example of noticing. If you think about noticing the court sends out an in-person summons to a family, and the notice, there's an attempt to go out to notify the family, and the family can't be found, and they've sent out the notice within timelines and everything, but maybe then the process server doesn't get it out fast enough or can't find the family, and eventually they're noticed, but it doesn't technically meet the timeline standards in ICWA. Those are situations that require maybe some different kind of communication between the court and process servers and affect whether a case is ultimately compliant for notice. So we're trying to capture these kinds of issues that interfere along the way and those qualitative. Can somebody tell me how I'm doing with time?
Yeah, you bet. You're doing great. You have about 12 minutes if you want to use them.
Okay, great. I'm catching up on questions here. What if there's a finding later in the case? Does the court flag the file then? How was active efforts done? What about continuances? Notice for original hearing, timely, but then continued. So we're actually looking at compliance at every single hearing. So if it's a continuance, then there should still be appropriate notification for that continuance. So how do you know if something is compliant? Here's an example of the way that we've had to kind of break down each variable that we're measuring. So we basically had to make a yes or no list for each variable. Are we going to count this case as compliant or not compliant? So the law doesn't tell us how to do this. In most cases, the BIA guidelines don't tell us how to determine whether a case is compliant or not. They give some examples of what compliance may look like, but they don't give you a yes or no. So you have to either use the measure somebody else has developed and really understand their definition, or you have to come up with your own definitions if you want to do this compliance work. So here's what we said. We said a notice to parents where the court is compliant if there's a documentation that all parties are noticed, that there's certified mail of notification, if with an active attempt the party cannot be found, or if the party is deceased. But sometimes we had cases where all parties were noticed and there was a missing parent or somebody who was not at the hearing who wouldn't have gotten that notice, just if the judge on the bench was saying everybody here is noticed, or there's no clear evidence of notice. And so we ended up breaking notice to parent into separate variables, one that says that there's a finding that all parties were noticed, and another that there's a certified receipt that meets the timeline with an option of, yes, there's certified mail or registered mail that doesn't meet the timeline. And then, again, we kept those qualitative comments if there are some weird things happening that we thought that we needed to develop a theme around. So here's a more complex example. We're talking about active efforts. We said that we would determine a case to be compliant with active efforts if there was a finding of active efforts by the judge or referee. So for every case we make a notation about whether there's an active efforts finding. However, we also make a notation about whether there's a reasonable efforts finding and about whether there's evidence of active efforts but not an active efforts finding. So one of the situations that we see a lot is that there's a reasonable efforts finding, but there's some descriptive text somewhere in the body of the report that sounds like there were actually active efforts. And the opposite is also true. Sometimes we see a finding of active efforts and there's no evidence anywhere in the case that there were active efforts. So this sounds complex and maybe even a little overwhelming. And it can be to get started, but it also just creates all kinds of conversations about what does this mean. And one of the conversations that's come out of our work here in our state is how do commissioners, judges on the bench know that active efforts have happened? And some have told me, well, the social worker tells me. And some of the social workers tell me, well, the judge makes the finding. So, again, we're in this kind of what came first scenario, and just having the conversation makes people think a little more deeply about it. Okay. So, because I'm a researcher, I couldn't just think about these like, oh, let's measure these 8 things, but I really wanted to know what case factors ultimately influence whether a case was compliant or not, and how do we get into the kind of the weeds about some of these things in ways that are actually going to make a difference in practice? Because I was trying to answer that question about how are these data going to be used, and how are they going to be useful to the field? So you probably can't even read the type on this list. What I'll tell you is that we're recording this in a SPSS database, and we're recording about 100 different variables right now for each court hearing. That sounds like a lot, and it is more time intensive than using a simple checklist. And we're going to be able to answer a lot of questions about this. Since we're looking at every single ICWA flagged child in our whole state, we're developing a database that is going to be pretty rich for answering some questions about ICWA. However, you might not have the resources or time to do something like this, and so this would be a shorter list. And when you think about it, even a list like this, I think that has about 4, 5, 6, 7, 14 items on it. If you think about that multiplied by every hearing that a child goes through, then this is still quite a bit of data to collect. So a lot of states might use strategies like doing some random sampling of cases, maybe not doing every case. We're quite a bit smaller than a lot of states, so it might not be feasible for your state to look at every single case. But this offers a little snapshot of things that you might consider measuring for compliance. And there are some great state checklists already out there. Sometimes people ask me for a checklist, and I hesitate because we really use that really long list of variables now, but also because this list is going to vary depending on which data you have access to and how and where it's recorded. and whether you have any other kinds of state laws that apply. Sandra's asking, oh, maybe she's not asking me. She says, did any of your random sample cases in the research include some that transitioned from state to tribe? Our cases are all state cases. We don't have access to tribal court data for this project, and we didn't use a random sample. We used a population sample, so every single case. So here's some of the juicy stuff, some of our findings. So we had, in our first data set, the 2009-2010 fiscal year data, we had 197 children who had 379 hearings. So we looked at all those variables for each of those 379 cases. About 92% of those cases said notice was provided to all parents. This is just a finding that everybody was notified. It doesn't necessarily reflect actual proof of notice found in every case. And also, notice to tribes was fairly high at about 84%. Most of the cases did not use QEW testimony. Only 30 of the cases in our sample reached termination, but of those, there was only a QEW who testified about the appropriateness of termination in 27% of the cases. Culturally relevant services were mentioned in only about a quarter of the cases. Active efforts, only in about half of the cases. Hardly any case mentioned placement preference using that specific language. Some of the cases mentioned things like, oh, the child is placed with the aunt, or there's a relative home study pending. So there's another kind of, you got to think about how you're defining the variable and what you're recording. Only a few cases mentioned good cause to circumvent placement, although most of the cases said that the children were placed in regular foster homes. One of our challenges is that some of the cases said that ICWA may apply through the life of the case without any clear acknowledgement about how the court was attempting to figure out whether or not it did apply, and without treating it as an ICWA case until figuring it out. And so we collected some data that's not necessarily about compliance, such as intervener status, and that happened in about a third of our cases. In about another third of the cases, the court reported no response at all from the tribe during the life of the case. Okay, so we're almost done here. One of the things that we did with this first year of data based on what we learned is we made some recommendations to the court, and these are the recommendations that we made. So this is sort of a university professor's dream as a child welfare researcher, to do this kind of work and submit some recommendations and have the courts turn around and say, we're creating an action plan for all of your recommendations. It's really exciting to be part of creating policy and practice change. And in this way, this collaboration was really grand. So some states have used, for instance, Casey has hired some states to do court monitoring, but it wasn't necessarily in collaboration with the state. Court monitors were used in open courts to go in and do some recording. And my impression of that versus what we've done is that we have a partnership instead of a kind of a outside monitor process that looks a little threatening. And all the time along the way, as we're working on findings from our case, I've been able to reach out to Heather or the person who was in her position before her and say, here's what we're finding, and next time you have the judges together, it would be good to talk to them a little bit about this issue. And so I think the partnership plan has had a major effect on changing and adjusting practices.
I agree, Melanie. This is Heather. I just want to say that based on these recommendations, when we're talking about the partnership, we took these recommendations and put them into an action plan through our subcommittee. So the CIP was able to take that to our administrative council last year in June for all of the judges to see and look at and approve. And based on that, we've got 7 recommendations that we've put into action, which includes many things from training to developing a bench card, making sure the standardization and location of documents are within the court files, and working with social services on their, they kind of have what is a mock affidavit or like a standardized format that they used, and we were able to talk with them about placement preference language in addition to that as well. So a lot of fun things we've been able to take from this and use on the CIP side.
So these are some of the things that have come out of our collaborative work. One thing that I mentioned earlier was that single county audit where we looked at all the documents together to see if there were kind of additive pieces of information that would increase where we think we are with compliance compared to just looking at the court record alone. We found that actually most of the time that those extra pieces of information didn't make that much difference in a compliance standard. One of the major exceptions is thinking about culturally relevant services. Those things are much more likely to be contained in the social services documentation. There was a little bit of a bump from in looking at active efforts in the social services records, but maybe not as much as you would expect. And listening to the audio of the court record helped a little bit in understanding how notice was provided. So I'll show you here. This is the bench book, and I'm sure that Heather can help you get a PDF of that. But this was created at the Supreme Court in the research analyst role. And it's also come through the ICWA subcommittee for review, and we all gave input on it. So it's been nice to be a part of that conversation as well. Do you want to say more about this, Heather?
No, I think I've uploaded this to the CIP share, so all can access it there. And I can send that out to anybody who needs it. But this has been distributed to the judges, referees, juvenile court officers, and directors, along with social service agencies, caseworkers, and attorneys throughout the state. So we all have the same hard card to reference. It's bright yellow and it's laminated in a hard card format and 3-hole punch, so everyone can take it along and it's easily accessible for them.
Great. So I mentioned that I think that we'll be able to answer some other questions because we've gathered so much data from each case, and some of these questions I think we'll be able to answer include, does the quality of case compliance predict return to the family? So one of the variables we document is where the children are at the end of the case. And so from a child welfare best practice standpoint, I want to know if the cases that have better tribal involvement and case compliance are more likely to lead to good outcomes for the kids. I want to know what factors like maybe rurality or age of the children or reason for removal predict poor compliance with a case. We want to know generally what effect this partnership has on strengthening ICWA compliance, and what strategies can impact compliance. So one of the things we're doing is we're presenting our data across the state. We present every year at our North Dakota Indian Child Welfare Conference. We hope that just having the conversation around data helps kind of elevate the concerns related to the things that we're looking for and create conversations around what is an ICWA compliant case. But the other thing that this has done is it's given us a real good data foundation to think about where we want to move next. And one of the areas that we're moving next is into some collaboration in preparation for a grant that we're working on, an Administration of Children and Families grant that will bring together the tribal court, the state court, and DHS, and our Indian Affairs Commission, and our university partnership and Child Welfare Training Center to look at more measurements on both the tribal and court side and strategies around policy and practice for improving compliance. So that's lots of talking. All right. So here are some good resources, some of the things that I talked about in this presentation, and you can just Google these titles if you want more information about these, but I think some of them are in your full packet already. Do we have a few minutes for questions?
Yeah, you bet, Melanie. What we'll do is we'll jump over into what we call the lunchroom. So this is the space that you're in right now. And we'll do a number of things, but we'll start off with about a 7-minute session of just straight up questions that people might want to ask. So first of all, thank you, Melanie. That was awesome. I will talk for 10 seconds so you can take a breath and grab a drink of water. You bet. Everybody that's in the lunchroom. And I moved the screen around, but it looks like a lot. It's kind of more, it looks like more than it is. In the upper right-hand corner is your chat. Bottom right-hand corner is the resource exchange. Bottom middle is Scott's email if you want to send us resources that have come up that you've thought of during Melanie's presentation. Bottom left are some questions that we'll address in a second. Just hold on to those for right now. We'll come back to those in a minute. Upper left is your attendees. And upper middle is where Scott and I will take some notes as we respond and work through those 4 questions. So the whole point in the lunchroom is, remember, in the community of practice, we're working on the metaphor that we're using, and maybe it's cheesy and I'll get rid of it, but for now, it's a lunchroom, not a boardroom. So this is sort of the working space that we want to be in. By the way, the lunchroom that you see on the front there is Google's lunchroom, well, one of the Google campus's lunchroom. I don't know about you. My lunchroom does not look like that. Maybe someday, but not yet. So that's the point in the design that you're looking at. So, Melanie, hopefully I just bought you enough time to catch your breath. I'll set the timer now. We'll leave it open for about 5 minutes of open Q&A. We ask that if you have questions, you can ask them one of 2 ways. Number 1, you can just type them into the chat, and Scott or I will read them out loud, and then whoever has the answer can answer it, or you can raise your hand if you just want to ask it over the phone. That's fine too. There's a little icon on the top of your screen that's a little person with their hand raised. Just click on that, and Scott and I will see that you've raised your hand, and we'll call on you. So I have the clock set for 5 minutes, and we'll just say ready, set, go.
Yeah, I think we had some questions come in near the end there, which I don't think we've gotten to. Do you want me to read those, Melanie, or do you see those starting with Sandra's?
I think I answered Sandra's along the way.
Okay. Sorry.
How about the Kansas CIP question? Did we get to that one? What is the process to determine whether ICWA does apply, and how long does it take to find out that information?
Yeah, so these cases are flagged in our system when the court determines that ICWA does or may apply. So they've gotten some kind of information that makes them think that ICWA may apply, and then they hit this little flag button on the case, and those are the cases that are sent to us. But then, hopefully, after that happens, the court is following ICWA law and sending a notice to the tribe to make an inquiry about whether ICWA applies. That has to be sent by certified mail. The best practice is that there's also a phone call or to try to get the process moving. But and then hopefully the tribe responds that, yes, the child is eligible for enrollment in our tribe or is not. And so what our courts told us is, well, they send out that notification and the tribes don't reply. So sometimes I've heard a sort of attitude about, like, why bother? They're not going to get back to us anyway. And I think that that comes from a place of frustration. But by ICWA law, the tribe should be re-noticed for every single hearing, whether or not they've answered.
And Melanie, this is Heather. I can speak to that a little bit. As far as when it's being flagged in the Odyssey case management system, from what I understand, it's as soon as they send that notification to the tribe, they're flagging that as an ICWA eligible case.
Yeah. So, and best practices on the social services side, I'm reading Anne's comment here that says that there's sort of a difference of perspective. Court feels like they've done all they need to, and the tribe doesn't feel like they have enough information to make a determination, so maybe they can't make a good decision about whether the child is enrollable. So social workers, child welfare workers can really kind of help this along by doing some a genogram with the family or family tree, trying to get more information about who might be able to tell them whether the child is enrollable in a tribe. There are things that can be done on every point of contact to help move that information along. But the case is really disserviced if the court just says ICWA may apply and nobody's told us whether it does or not, and so we're just going to kind of move on because there's no way to promote the kind of involvement with the culture and tribe and let the tribe make a decision about their involvement if we can't get a clear picture about the eligibility. Yeah, we've asked that question some, Anne, and I think you're right. The answer is complicated, that it's about lack of resources sometimes. Sometimes it's about lack of information. Sometimes it's about the relationship between the court and tribe. Sometimes it's because the notice has been sent to the wrong person. So the BIA has a list of every ICWA worker for every tribe that you can download, but there have been stories of, for instance, notification sent to the chair of the tribal council, and that's just not the right place for it, and it might not ever get from the chair to the ICWA worker.
Good. Thanks, Melanie. It looks like we have a couple other questions. Sandra asked, I'm just calling up the chat a little bit, has anyone developed a tool for the families or child?
Do you mean to do an audit of the social services record?
That's a good question. Sorry, I just fell victim to the mute button there. Sandra, do you want to, I see that you're typing in the chat, do you want to just over the phone kind of add some context to your question?
The question, basically, my question was a tool. I know in the process you guys gather a lot of information, and we're looking at tools for the workers and the frontline staff and the courts. But I have worked with a court that actually has a tool or a booklet that's offered to the families as well to understand some of the jargon, the processes, what to expect, because sometimes they get thrown into this and they really start scampier and not understand what to expect. So I didn't know if there was like a tool or develop something along the way with all the information you've gotten.
Yeah, we don't have a tool that we hand to families that explains ICWA, to my knowledge. However, we do have several ICWA forms that our state social workers are supposed to use, and ideally those forms would be filled out and then go into the court record, and they would help justify compliance. And our workers currently don't use them, and it seems like we're having a hard time to move them to that place.
Thank you.
Gotcha. We have about another minute or so in the open format here. I'm wondering, Dr. Summers, you mentioned using focus groups to supplement quantitative data. I mean, I don't know, maybe that's just because I drank the Dr. Summers data Kool-Aid. That makes sense to me, but do you want to maybe unpack that idea just a little bit?
Sure. So I was just thinking, this actually comes up a lot, the difference in perceptions related to the data might say this, that everything looks fine, but that's not the perceptions of the stakeholders involved in the group. And so what we'd like to do when we're trying to do this data, the file review really is a great opportunity to see what findings are made. You can get placement from that. So a lot of the things that we would look for in compliance are in the file review. But if you use that as a starting point to follow up with different stakeholder groups and ask them why something's occurring, where they see the challenges, where they see the successes, you're going to get a lot of different answers. And so we try to do that multi-method approach whenever we can, because talking to the tribe or the person that you would work with from the tribe when it's an ICWA case often gives us really different information. And so I should say we use focus groups in two ways. One, to inform what kind of quantitative data we're going to collect, because we might want to look deeper into something if someone identifies that from a focus group as an issue, or two, to provide that additional context and information about why there might be misperceptions or where some areas are that you could focus on, or if you have an area of low compliance, why that might be, what the actual challenges are to get in that. So I think it's just a good opportunity to understand it at a deeper level that gives you something qualitative in addition to the quantitative stuff that us researchers like so well.
Absolutely. Those are good points. If I were going to do a broader study, I would look at that. One of the implications of that is that right now we're looking at secondary existing data, so that direct contact requires some extra steps with the institutional review board. So that's a consideration. And we also used our ICWA subcommittee in a similar sort of way, ask them, what does this mean to you, and what do you think the challenges are, and what do your people tell you? But we also drew out some questions about especially tribal state court relationships, because we saw that, there are some tribes, or maybe a certain tribe county court pair that collaborated really well together, and then that same tribe maybe wouldn't intervene as often, or wouldn't help with the QEW as often in a different county. So that speaks to relationship issues, and I think that learning about those in your state are really important if you want to improve ICWA compliance.
Thanks. I thought I heard somebody wanting to ask a question as well there. I'm not sure. Anne, I saw you. Is that you?
Yeah, this is me, Ann Gilmore, because I do think that one of the problems we have is you can talk about collecting the data, and we definitely need to collect more data and have different data points in California, and we're gonna look at ways to do that. But one of the important data points, if it's just the court and county, state courts and the counties, child welfare, that are recording their data, there's an inherent bias there, because it's always going to be their judgment about whether or not they complied. And I think that in some key areas, even if the court makes a different ruling, it would be really important to know whether the tribe agrees with that or not. Like, does the tribe agree that active efforts have been made? And so that even if the court is making its finding, yes, active efforts have been made, if the tribe doesn't agree and you can see that tribes don't agree with those findings, you can identify a problem. So if you know what I mean, so it's not just the court and the county, their conclusion about what they've done that is showing up there. Because I know often in California the tribes will say, well, the judge made the finding of active efforts, but we don't believe there was the record there to support that finding, and counsel at the trial level didn't protect the record, and so you're not going to see that on appeal. It's not going to work its way through the system any other way. But there's still this feeling within the tribes that the data doesn't reflect the reality on the ground. So trying to find a way that we can collect that data, but it doesn't sort of squelch, it doesn't have the effect of squelching the tribal position, if you know what I mean, and has a way of incorporating that, because I think it is a real problem, because if all we're doing is finding ways to spit out numbers that support, that don't reflect the ambiguity around these things, I think it can do more harm than good. That's my thinking of how we try to tackle it without it just being a papering over it.
Absolutely.
Sorry, that wasn't very clear.
No, I resonate a lot with what you said, and it goes back to my first slides, right, about who gets to create the measure,
right,
and who might it harm and help, and what's missing in because of the data source that we had access to for the moment. I think that you would.
That's right.
Like our report, and which kind of gives the numerical value for each kind of variable we look at, and then has a few paragraphs of, and this depends, and this might not be the right answer.
Right.
All these things. So it is complicated, and our systems do want a yes or no answer, and we're never going to come to a good place at that. We can't completely let the tribes identify whether or not there were active efforts, because that would have bias too, right? So, I mean, either side of this, how do we kind of negotiate those measurements, and how do we say, this is the data that we had access to at this point, and here are the reasons it's flawed, and here are the reasons it's helpful. Yeah.
Great, thank you. That was, man, I have like a bajillion notes jotted down on my notepad here. That was super helpful to hear that conversation for me. Definitely working with the Center for Courts on our ICWA work, so thank you for that. What we'll jump to now is we'll open up the conversation to figure out what our next topic's going to be. We do have about a 7-minute carve-out for some open space Q&A, so if anyone has any questions for each other, it could be for our creator or some of the folks that have identified some issues with ICWA compliance and data, that would be a great time to ask that question. But when we get to the open space, you won't be limited to that topic as well. You can ask really questions about anything. Not that I can guarantee that you'll get a good answer, at least from me, but certainly can ask it. So my question now to the group is, if you'll just respond to the poll, which of the following should we work on at the next meetup? So just take a second to respond to the poll. You can choose one of those items. You'll notice that this list is growing from month to month, and partly that's because people send me things that they'd like to work on throughout the month, and then I just include it in the list, and we vote on it and move forward. If you don't see something that you want to cover or work on as a topic or a subtopic with ICWA, just go ahead and type it into the short answer there at the bottom, and we'll fold that into the voting as well next time we circle around. So I'll set the timer here for about 2 minutes, but I'll also keep an eye on the flow of the votes as they come in. If we could just get everybody's input, that'd be great. Again, this community exists for you, so you're guiding it right now by voting. Thanks. Oh, one thing I failed to, here, I'll put that up now. There you go. This is some data that we gathered at the CIP meeting last time. It's a infographic that Scott threw together. I'm sorry, Scott, I shouldn't say threw together. It's an infographic that Scott designed, and it looks wonderful. If you're wondering where some of these topics came from, not only are they organically sent to me, but also they're reflected in the data that we gathered from the CIP community. Take about 1 more minute here. We might not need the full minute, but we'll take about 1 more minute for people to vote. Good. Thanks to those who are typing in short answer stuff. You'll see those options on our next meetup when we vote for the topic, so thanks for that. All right, looks like the votes are slowing down a little bit here. We have, oh, they're still coming in. I'll give it a second. Yeah, good question. Scott just typed into the chat. Can whoever added those 2 new topics elaborate a little bit in the chat, just so that we make sure we understand? That's good, especially keeping it in the chat. That way when I circle back around and throw them into the multiple choice pod, I can kind of refine it or drill down a little bit on what you're talking about there. Good. Thanks for that. All right. It looks like I'll just kind of keep moving. The chat pod's not going anywhere, so keep typing into it. I see that some of you are responding, so that's great. Thanks. I'm going to go ahead and make the call here just based on, well, you made the call. It'll be engaging tribal CIPs and leveraging resources. That's going to be the topic for our next meetup. Just jotting this down. Good. So now the question is going to be, you should be asking yourself right now, is that a topic that either I can speak to, that I have experience with, or that I know someone who has worked with that or on that topic? So we'll jump over here to what do you want to contribute to the group. So again, engaging CIPs and tribal CIPs and leveraging resources between court improvement programs is the topic. So the question, I knew you were going to say that. Thanks, Angela. I'm jumping back now to our previous poll. The topic is engaging tribal CIPs and leveraging resources to do so as between the court improvement programs. So thanks, Angela. Scott, maybe you can just jot that into the chat as well when I move us over to the roles. Again, engaging tribal CIPs and leveraging resources. So the question now is, what role would you like to play in next month's meetup? So again, you can be a consumer, which is someone who's participating by consuming the content. If you're present and you're getting it and you're getting the information, then you're a consumer. Everybody's something. Creator is someone who can speak to this content. Now remember, you might not be the creator yourself. Maybe you are. But if you think you know someone who's worked on this, or a handful of people who have worked on this issue, you can identify yourself as a creator, and just like Heather did this month, and say, hey, I'm not the creator, Melanie is, but I can get you the creator to come and present for us. Or if you feel like you're the creator, that's fine as well. Connectors are people who help others to find content info and people they seek or need. So for example, this might be, I'll just make it up. Let's say Scott is the creator for next week, and he says, boy, I know that there's these really great tools that are out there because on ICWA compliance, because I've heard you, or I mean on engaging tribal CIPs and leveraging resources, because I've heard that they're out there, but I need someone to help me track them down. That's your connector. Carrier is someone who's going to help transmit the information. So this is just kind of really your big task is easy. You draft up the summary at the end of the meetup and then send it to me and I shoot it out. So that's really all that is. So if everybody will self-select, that'd be great. Again, consumer, creator, connector, or carrier, and the Center for Courts will be the caretaker, and make sure that we're all on task. So I'll set the timer here for about 2 minutes and give folks a chance to think about that and then self-select. Great. Yeah, and I appreciate that. You definitely don't need to apologize. This community is not mandatory for anyone. You can come and go as you want. The design of the community is that it attends to core participants and periphery participants and trainees as well. So I appreciate that, but no need to feel sorry at all. Great. Yeah, Angela, I see your comment there. Is that someone that you can connect us with? Excellent. Okay, cool. So maybe what we'll do, and Angela, is make you the sort of creator / connector, with the idea being that we'll reach out to that person, and if they can't make it, then obviously you're not the creator, and we'll find someone else. Gotcha. I see just a few more folks are typing in. Angela, don't be scared. I'm going to type in your name and then just write, just for my own records here, creator. Everyone's scared of being creator connector, knowing what we said. Got it. All right. And if we don't have a creator for next time, that's an interesting problem that I haven't addressed yet. So maybe what I'll do is reach out to some of the connectors or even consumers and see if we can't identify someone as a group. So, good. All right. Okay, so now let's pop over to the open space. And we have a few minutes left here. We got about 11 minutes left. And what we'll do here is just kind of open up the lines and the chat box for whoever has questions. So anything that you might have for Melanie or Heather, this month's creators, or questions that you might have for the Center for Courts more broadly or for each other, this is absolutely the time. So yeah, again, unmute is *6, or you might have a mute button on your phone, or maybe you've done both. So you need to unmute yourself. Otherwise, I will be quiet. You can raise your hand or just type into the chat.
Hi, this is Bridget Bauman from Wisconsin. Can you hear me okay?
Yeah, we can, Bridget.
Okay. This is a question for North Dakota, and I apologize if I missed it. You had mentioned, or someone had mentioned, that there were social worker or the department is using standard forms. Does North Dakota also have standard circuit court forms for ICWA cases? Because Wisconsin does, and that has made all of the difference in monitoring compliance and helping with compliance as well.
Heather, do you want to take that? The short answer is no, and we think it would be a good idea. We have the bench book. I'll let Heather talk.
No, I think Melanie's absolutely right. We do have the bench book that the judges use as far as, what they reference when looking at definitions and ICWA law. But no, we don't have any circuit court forms that are used.
Great, thanks. Ann, I see that your hand is raised. I'm going to jump to Casey and Stacy and then back up to you, Ann. So Casey and Stacy asked for Melanie, what would be examples of case-related factors for the question about predicting poor compliance?
So an example might be that the children are from a really rural county, or it might be related to the tribal affiliation. So, for instance, if we found out that maybe our courts really don't know how to interact with a child from a certain tribe, then that would be a valuable piece of information for thinking about what we need to do different.
Gotcha. Thanks. And Anna, I see your hands raised. You want to go ahead?
Yeah, well, what I was wondering is whether we could sort of create a subcommittee. I've had about the case management system, and in particular Tyler Odyssey. I know that in the first meeting, someone from Minnesota mentioned that they use that case management system, and then I understand North Dakota has that, and there's some flags in that. I know that in California, about 70% of our courts are moving on to Tyler Odyssey, and so it seems like maybe it would be something that would benefit from some sort of more national discussion about what the ICWA elements in that case management system should be and how they could be incorporated. And so I'm not at all a techie person, but I have lots of thoughts about what ways that you could flag things so that courts can do a better job of overseeing ICWA compliance. And I just wondered if it might be useful to create a subgroup of folks that would be interested in working on those elements.
This is Heather from North Dakota. I think that is a great idea. Anytime we can get together and gather around, and especially everyone who's using the same system, I think it makes sense to do so we can use each other's expertise and ideas. So I'm game.
Yeah, thanks, Ann. That's a really great idea. So let me just put that to the chat. If you're interested in sort of a subgroup where you get together and work on some of these data collection issues, and I'm trying to use your language, Ann, but I'm going to not do a very good job of that. Flagging certain issues and using the technology to really gather the right data or data that's relevant. If you want to, and maybe Ann, if you want to restate what the ask is, but what I want people to do logistically is to type into the chat if that's something they're interested in doing, and then as a subgroup, you all can just run with it and have that those conversations sort of offline with the invitation that maybe you can circle back around in, 3-6 months and kind of give us some insight as to what you've learned together.
So my idea was a subgroup where we could look at how we integrate ICWA elements into the Tyler Odyssey case management system. And in particular, I would like there to be, more than just one flag, but a number of flags as a case progresses so that judicial officers can do a better job of overseeing ICWA compliance.
Excellent, thanks. So if you're interested in working on that subgroup, I'm not sure if I spelled Tyler right. I think that's right. Just type in your name or yes or something like that, some affirmative statement under what I just typed so that Ann and Heather know that that you're interested in that. And then everyone gets a update. Each month I update the contact list and send that out with the summary that follows the meetup. So I will identify folks that are interested in this subgroup in the summary, and then you all will also have each other's emails as well.
Great.
Yeah, that's great. All right. Let's see, just a couple folks typing in to the chat. Wonderful. And then we'll close out in just a second. Yeah, gotcha. Oh, Melanie, I should have said early on that we all agreed as a community when we first started this thing that there's no grammar police. So misspellings are totally welcome. Good. All right. So I see, looks like the chat's slowing down a little bit. All right. Wonderful. That's great. That's really cool that that's happened. So, all right, so we'll go ahead and close out now. As always, on the way out the door, we have just a couple things that we'd ask you to respond to. Actually, 3 things, 3 polls. When you're done responding to them, you can close out. That's fine. I'll stay on the line until a couple minutes after 1:30 Mountain Time, 3:30 Eastern. In the top middle, you have what portion of this meetup was most valuable to you. So this will kind of help direct how we carve up the time, and if we need to eliminate some things because they're not valuable, that's helpful to us. In the upper right-hand corner, just the potential dates for the next meetup. Bottom right-hand corner is we're kind of CQIing our own process to make sure that the entire community of practice is valuable. If it's not, as always, the commitment is that we'll stop doing it. But if it continues to remain valuable, then we'll continue to do it. So that's all I have. I would like to especially thank Heather Trainer for her work in North Dakota, specifically on ICWA, but also in this group. She's done a lot behind the scenes, and I don't mean to embarrass you or put you on the spot, Heather, but I have to tell you from my own workflow, you've been invaluable, so thank you for that. And I also want to thank Melanie for putting together what is obviously a very fruitful and substantive presentation for us, which no doubt will translate into more informed work on the ground as each one of the CIP work on ICWA compliance and data collection. So thank you very much to both of you. That's all I have, 2 minutes early. Have fun if you use those 2 minutes to get some candy or a cookie or something before you go back to work. It's been a pleasure, and like I said, I'll stick around, but otherwise you're free to go. Thanks again, everybody. We'll see you. Oh, I guess in 2 minutes it's not even close. May 18th from 2 to 3:30 Eastern is our next meetup. I'll send that out in the summary. So there you go. Have a great day. Thanks, everybody. Bye. I don't know the answer to it.